been shown as we get this 4 o'clock meeting started at 4:40. But we were waiting on Legislative Council to finish drafting a sub that would be coming up. And as we get started in this meeting, I'm going to ask Chairman Fleming if he will start this meeting off with a prayer.
Please bow your heads with me. Lord, we thank you as we always do for our ability to meet in this house as this committee. We ask you now as we begin deliberations that you would give us the wisdom and enlightenment that we need to do what is best for the people of this great state. Bless us and keep us now as we move forward. Amen.
Thank you, Mr. Chairman. As we get started here, just a little bit of housekeeping. We do have a witness sign-up sheet that a number of individuals have already signed up on. As I referenced, we have a committee sub that is being copied right now. For those of y'all who are joining us electronically, you will be receiving it through email. So keep a watch on your email. It should be hitting any second now. But we're going to go on and start the meeting. We have one bill on the agenda today. It's Senate Bill 288 by Senator Anderson. As we were talking beforehand, a member of my freshman class up here. Senator, it's always good to see you, even though you abandoned us in the House. And it's going to be carried in the House by Representative Houston Gaines. And so, Senator, do you want to start off and have anything you want to say before we get into let Houston say what he wants to, and then we'll move forward, or however y'all want to do that? I'll let y'all divide up. You can actually be right there if you want to. If you'll just tell me what number that microphone is. All right. And as we're going through this, reminder for all the ones who are joining us via Zoom, the committee members, if you would, if you have something you want to say, kind of just wave, do something to catch my attention. Some of you have my cell phone number, so you can always send me that, or on the chat. Hit the raise hand button on the chat. So, all right, Senator.
Thank you, Mr. Chairman. I'm trying to hold it up because it's sliding down. Thank you so much for this opportunity to come before you. Senate Bill 288 is a statewide initiative to put Georgians back to work, to allow people to have jobs, an opportunity for a second chance. And it is supported by a lot of organizations, some faith-based, some non-faith-based, the business community. But as I was putting this bill together earlier this year, I realized that out of 11 million Georgians, 4.3 have some type of a record. And this bill allows for those records to be restricted and allow people a second chance at life, for jobs, for housing, for employment, as well as school. And it gives them an opportunity to feel the confidence that they had once before, to be law-abiding citizens again, and to have contribute to our society and to our state. But at the end of the day, it would eradicate poverty, it would eradicate homelessness, and there are people who want to provide for their families, but because of the restriction, or their records rather, that they are limited. And so this bill would help all of Georgia, but out of the 11 million, the 4.3 that really need that second chance, it would help build up the economy in Georgia. So I thank you for the opportunity to bring this bill along with Representative Houston Gaines to your committee to allow for an opportunity for Georgians to get back to work.
Thank you, Senator. Chairman Welch.
I want to thank the senator for bringing this, and Houston, thank you for sponsoring in the House. You know, we have spent a decade as a institution in government working on criminal justice reform, and we have done it systematically and over that period of time, with the sole purpose of trying to give people a second shot after they've made a mistake for nonviolent offenses. This seems to dovetail with that purpose. Senator, what made you want to bring this bill? What drove you? What was your, we share a common district. We overlap. I feel like I know you very well. You have a very caring, compassionate, and driven heart. But what inspired you to bring this?
Well, over the years, I started out in local government, and people who needed jobs or wanted jobs, or even wanted, another opportunity, felt the barrier of, and restricted by their record. They would always ask if I was in the community, out in Newton County specifically, and or Rockdale, and they would say, "I need help. How can you help me?" And I didn't know how to help. I didn't know, how restricting that this is, for people. And the more I looked into it, and the more I, had dialogue with my colleagues in the Senate and in other states, I noticed that they were having the same problem. And it's just was an opportunity for me to see people, have hope and get their life back. And so this just prompted me to say, this is something that would be great for Georgia, and it would help just so many people. And there is no limit to who it can help when it comes to, party, religion, race. It helps all of Georgia. So that was my driving force, because I would be out in the community and people would want help, and I just didn't know how to help them.
Mr. Chairman, my law partners and I have a little law practice in South Metro Atlanta, and as an employer, I run across this from time to time, and we believe in giving people a second chance. We believe in there's always a path to redemption, and so this fits in this. And what I like about the bill, when the sub has changed, I know the chairman will tell me, but if you're given the second chance to have those records effectively separated, but if you fail in that second chance, all of it comes back in. Mm-hmm. So there is a penalty for abuse of this, if you will, or not abuse, but just there's a penalty in the sense that if you fail to succeed in taking that second chance, taking full advantage of it, then you will lose the privilege that this bill offers. And so I like it because it still has that measure of accountability in it. And there still is that sense of you have done something wrong to have been put on, and you've been found guilty of that to be put on this registry. But in giving that second chance, society gives that second chance, but at the same time protects society in that a failure to comply with that second chance and live through that second chance, make the most of it. And if you are a repeat offender, then that record comes back in full, and those consequences are there, to protect society's interest in someone that has failed to take full advantage of the second chance. Mm-hmm. So I like that aspect of this particular measure. But I'm glad you brought it. I think it's helpful to employers, and I think it will be helpful to employees as they search for jobs, better paying jobs.
Absolutely. Thank you.
Thanks.
Thank you, Chairman Welch. And I see that Whip Bodie has his virtual hand up. And so, Mr. Whip, let me turn my mic off and come to you over there.
Thank you so much, Whip Kelly. I really appreciate that. I just want to say to Senator Anderson, thank you so much, because I know we have been talking right before you actually filed the bill, when the bill was going through the Senate, and now here in the House. And the one component, there's many components I like about the bill, but I think this is the first time, and Whip Kelly and the other attorneys in the room can maybe attest to, where we actually have an opportunity to address pardons. I know in my practice, just like Chairman Welch, I do quite a bit of criminal defense work. And I had a client about 10 years ago that had a burglary charge, and it dealt with him having some substance abuse problems. And he actually had a burglary against his own father. It was down in Fayette County, and we were able to get him a pardon. He out of trouble for 5 years. He was an auto mechanic, and I think one of the proudest days of his life was getting that pardon. But now I can go back to my client once this bill passes, because I think we're going to get it across the finish line and say, now you can have your life back and not only have the pardon, but have your record restricted. And so thank you so much, Senator Tanya Anderson, for what you have done. Thank you to Majority Whip. I know you've been working very hard on this, but also I want to thank all of our allies that have sponsored and endorsed this bill. And hopefully we can get it across the finish line. And I think this is one of the instances where we have some good bipartisan participation on both sides of the aisle to do the best thing for the state of Georgia. So thank everyone involved, and thank everyone for being involved in this process of vetting the bill and hopefully passing the bill out of this committee today.
Thank you, Mr. Whip. We're going now to the House sponsor, Representative Gaines. And if you want to bring in do you have anything you want to say while you're here by yourself, and then we'll bring in the witnesses? What number are you? Are you 11?
Well, thank you, Mr. Chairman, and thank you, Senator Anderson. I've enjoyed working on this issue, and and I also want to thank Chairman Mandy Ballinger, who helped introduce the House version. We've been working, but this is something that's obviously been a part of the process for years, and really seemed like this session we're going to be able to get something done. And it's been an honor to be a part of this process. I know we were having meetings over in Athens last summer about it, and to see it here, I'm excited about where we are, and hope we can get this thing over the finish line this afternoon, and continue to move it through the process. But this legislation, obviously, it is a significant criminal justice reform that will continue to move our state forward. I know that Georgia has just done great work leading the nation in criminal justice reform, but I do think this is an important part of that process, as 41 other states have these sort of policies in place, and certainly something where Georgia, where we need to step up to the plate. In fact, just in 2019, last year, Oklahoma, Kentucky, and Mississippi extended record restriction eligibility to include more felony charges. Missouri, Louisiana, North Carolina, and Texas extend eligibility to include more misdemeanors. So states that are comparable to Georgia are also doing this. The legislation that we have today, it's changed throughout the process significantly. But I think we're at a place where everybody has come together and agrees on the legislation. And so we're working with misdemeanors and folks who've not offended for 4 years, giving them the opportunity to get this off the record. And we're excluding certain offenses, certain misdemeanors that I think we all can agree are relevant to continue to have those on folks' records. And so I think this is a very strong piece of legislation that sets Georgia on the right path, and appreciate the chairman letting us move this or have this hearing and hopefully a vote. We do have Marshall Guest with the Metro Atlanta Chamber, and then Brenda with the Georgia Justice Project, who can kind of walk through maybe some of the more specific questions as they come forward. But maybe Marshall, we could go ahead and have Marshall come in and give the business community side.
And Whip Bodie, do you mind putting your hand? Okay, you got it now. Thank you. No, you can remove your mask when you testify to help you hear, allow us to hear you a little more clearly. So if y'all two would just state your names for us and who you're representing, and then give us your thoughts on the bill before us.
Thank you, Mr. Chairman. Marshall Guest, Metro Atlanta Chamber. It's a pleasure to be with you today. I'm joined by my colleague, Amy Lancaster King, our Director of Workforce Development.
Thank y'all for both being with us today.
Mr. Chairman, members of the committee, thank you for the opportunity to be with you today, and thank you for allowing this bill to be heard, especially in the fast pace of this session that we're in. Just to kind of give you a sense, the Metro Atlanta Chamber puts a real emphasis on workforce development. It's something that we believe in greatly, to the extent that we have my colleague here, Amy, and her sole focus is working on workforce development issues. And so she's been very engaged in this process over the last few years and how to improve workforce outcomes. And much of the policy work we do, we've learned that has to go beyond policy. And we can focus on crafting good policy, but we also have to focus on programmatic opportunities too. And Amy's done a fabulous job of putting programs in place in conjunction with our partners to help improve those workforce outcomes. So the bill before this committee today, obviously we believe strongly in it because it will help returning citizens gain employment and fill open positions while also ensuring that employers have appropriate liability protection. I think we know that unemployment is directly correlated to recidivism, which puts a strain on families and state resources. These reforms will not only reduce barriers to employment, but we believe will also help grow our tax base, reduce crime and costs, and help our economy and our communities thrive. Expanding restriction, will save employers significant time. I think that's important to point out, and money in the screening process of applicants by removing conviction information that is not relevant to the hiring process. Georgia employers are implementing these policies now and strategies to include more people with criminal records, but it's onerous. This bill expands opportunities for individuals to have their records restricted, as I mentioned, and reduces barriers to employment. And we're thrilled with that aspect of it. By passing Senate Bill 288, if this committee so chooses to do so today, we believe it will further our efforts to keep Georgia the #1 state in the nation in which to do business, and also to foster a more inclusive economy. Thank you, Mr. Chairman, for allowing me to make comments.
Thank you, Marshall. And Amy, do you have anything you want to add there?
I'm here to help answer questions.
All right. Chairman Fleming.
Thank you, Mr. Chairman. Appreciate y'all being here today. Appreciate the work the chamber does. I begin with the supposition that employers, the purpose of this is to encourage employers to hire people that they otherwise might not hire. Is that correct?
That's correct. Amy, you can speak to that as well.
Yes, so that is part of it. There's already a lot of work happening in that space, but as Marshall mentioned, it is onerous. So how can we make that easier? And this is one of the ways to do that.
So as I understand the function of the bill, and I know that we have a substitute, and Mr. Chairman, you know about the substitute, and I think this issue that I'm about to ask about, so you may have comments, but it seems to me that one of the key provisions for you is the idea that if you hire someone and you didn't know about their criminal record because it had been expunged in some way, that you would not be held responsible for not knowing. Did I state that correctly?
Yes.
I believe you did.
Okay. Now, I know that the liability piece that came out of the Senate is going to receive a change in the substitute, if I understand it. And I'm not asking y'all maybe to explain that change, but ultimately I do want to ask somebody about that and try to understand that portion of it because I think it's important to you.
I'll be glad to explain that, Mr. Chairman. The original bill on line 580 talked about the admissibility of the criminal history record, and it said the nature of such criminal history record information is not directly related to the facts underlying such proceeding. It originally said is not directly related. And I essentially just deleted directly related and substituted in the more legal term I felt appropriate, which was relevant. That was the change that was made in that aspect.
Is that going to change the liability protection for the employer?
I didn't feel it did there. I just felt it made it more clear.
So you think the liability protection for the employer is as strong in the substitute as it was in what came out of the Senate?
Yes.
Mr. Chairman, if I may, based on the conversations we've had with the chairman, we believe that this language change is adequate to ensure that the employer liability provision remains as strong as it was. That's our initial read, Mr. Chairman.
Have you had your lawyers look at it?
We've had some consultation.
I always want people to be represented.
I'm sure you do, Mr. Chairman.
Thank you very much, Mr. Chairman.
Chairman Welch.
Marsh, you said that was your initial read of it. Do you expect a subsequent read of it?
We'll continue to confirm and make sure, but based on our initial read and the assurances of the chair, who we have great faith in, we believe that that language meets the needs of the business community in this aspect.
Yeah, because I mean, it's good to provide the applicant or the prospective employee with this benefit, but if there's not assurances that the employer is going to be protected, then this is a marriage that will never occur.
Right.
So I think that Chairman Fleming's point is extremely important.
And also, if I can just real quick, Mr. Chairman, it is my intention not to have changed it. I just felt like relevant was the more proper legal term versus directly relatable.
We heard earlier that 41 states have provisions that are similar to this. What has been the success in terms of, if you know, in terms of there being an actual quantifiable number of change in terms of employees that previously, if the system wasn't there, this legislation was not in place. How dramatic of a change in the employability of individuals that had a record? What numbers have we seen in other states? Can we quantify that and tell us how this has been helpful in actually moving that needle?
So I don't have specific numbers to that. Brenda may be able to answer that question more directly. What I do know is that retention is higher for those individuals that have gone through the second chance process in order to obtain employment. And so that is a key component. And then the other piece is recidivism is directly correlated to whether or not they have a job.
Mhm.
And so if this helps people get into employment, it helps them not to get back into the prison system.
And explain how this helps employees retain their jobs or employers retain them as employees.
So when an individual has a criminal background, it's challenging to get employment, period. So when they are able to get employment, their loyalty factor is way up. And so that's how they are retaining, and not lack of turnover, as I've read in studies, is similar, but retention on the loyalty factor is much, much higher.
And what studies are we talking about here?
I can send it to you. I'm sorry, I don't have it off the top of my head.
I'm just trying to get a sense of these anecdotal. Is this Survey Monkey? What are we talking about?
No,
here?
it was a published research paper. So I don't remember, but I'm happy to send it to you. But I know that doesn't help you in the moment. Sorry.
Thank you. Further questions?
No.
Chairman, are we going to hear from prosecuting attorneys and that?
So right now we have the Metro Chamber, then the Georgia Justice Project is going to come up, and we're going to allow them to probably stay with Houston throughout the rest of the bill presentation. Then we do have Gactyl, PAC, someone from the Faith and Freedom Coalition, and then Mr. Weaver going to testify as well.
Would it be all right if I asked a question at this point in time, and maybe
Yeah, absolutely.
Thank you, Mr. Chairman. So I appreciate what the witnesses have said. This is Thank you, Mr. Chairman. I appreciate what the witnesses have said. This is very important policy for our state. I was speaking to a group of constituents last night, was addressing this issue. I know it's top of mind for many constituents. As I've said many times, I believe the committee I chair had 3 hearings on this issue this year and maybe into last year. And as I've said before, I think there's broad agreement on the policy. The question is just a lot of the mechanics. How's this going to work in implementation? So I'll just put a couple questions out there now. And I'm told that one of my bills may be called in the Senate Judiciary Committee this afternoon. So I might have to go, and I'll just leave it for the benefit of my colleagues who are here. But we of course just received the substitute. Is it fair to say that we're talking about only misdemeanor offenses would be subject to records restriction and a sealing of the clerk's record? Is that correct?
With the pardon.
With the pardon piece as well. Okay, sure. And if we just go through, just want to make sure I understand this. On page 8, at the bottom of page 8, we're talking about, and then reading on to the next page, we're talking about, it could be multiple misdemeanors that are in 2 different cases, right? So it could be 2 series of misdemeanors would be subject to restriction. Is that correct? All right. All right. And so I just want my colleagues to be aware that we're talking about, and in committee, many times we'll come up with hypotheticals, but it could be a long list of misdemeanors in one accusation, then another case with a long list of misdemeanors, or potentially cases in different accusations that are consolidated for the purposes of trial that would only count as one conviction. And so I just want to make sure I was clear about that. And that would also, we were talking about the pardon piece earlier. Pardon piece is 303 to 317. Pardons would also be subject to sealing in the clerk's record if they met these qualifications. Is that right? Okay. And so, and it looks like there'd be a hearing requirement for that. You'd have to petition the judge and then have a hearing for the, is that a higher standard than just a normal conviction? Okay. All right.
And the pardon piece was something that the Senate, it was an amendment for the Senate.
I think the pardon piece makes sense logically,
Right.
but it would apply to felonies.
With some
Exceptions, yes. Yeah. All right. Okay, so just briefly, Mr. Chairman, I'll just detail an issue which I think our witnesses are well familiar with, but this is on my mind because our evidence code 24609A2 allows for the admissibility of convictions for the purpose of impeachment even a misdemeanor. If an attorney is unaware of what those misdemeanor convictions are, it's impossible to, or doesn't have access to the clerk's file to get them to introduce. There's an issue there. I have attempted to work with the parties in the hall about trying to work this out, and we haven't been able to make any headway, unfortunately. So I have a proposal for the committee here, if that would be acceptable. And this would be, and bear in mind also, the list of offenses that are non-restricted will very much pare that down, because certain theft offenses wouldn't be eligible for restriction. Certain sex offenses, things like that, are still ineligible for restriction.
Let me do this if I can.
Yes, sir.
Chairman Efstration, I think who are the parties you've been working with kind of in this vein that haven't come together? Because I think the chamber, if we're looking to maybe get someone who can talk with us more about the legal side of it, I think
Yes.
I was going to release them and bring in that other party that may be a little more able to answer the
Absolutely.
question.
I'm sorry if it's the
No,
wrong witness.
No,
Yeah.
I'm thinking as I've kind of heard where you were
Yeah.
going, I think especially with language, do you think it's Gactel and Pack that we need to bring in right now?
That might make sense. I think this isn't really in a criminal context that I have concern, but I'll yield to the chair as far as what the most appropriate witness would be.
Well, let's do this. I want to thank Marshall and Amy for being here and for all y'all do for our area. And I think I do want to bring in Brenda and Jill and Robert so that they can hear the language that Chairman Estration has for us so that we can all kind of stay on that same page if that's if the committee's acceptable to that.
Thank you.
Thank y'all for being with us.
Thank you, Mr. Chairman. Thank you, members of
Get
the
all
committee.
three of them. Yeah. Let's let him finish as I interrupted and I'll come to you. Hey there. We'll just let y'all pick microphones anywhere y'all see one available. And the speaker has kind of told us that it's acceptable for us to remove our mask when we're speaking on the microphone so that everyone can hear us clearly. And if y'all go around, I think we know everyone here, but just go ahead and introduce yourself to the committee.
Good afternoon. I'm Brenda Smeaton. I'm the legal director of the Georgia Justice Project.
And I'm Robert Smith. I'm general counsel to the Prosecuting Attorney's Council.
And Ms. Travis, what number are you? 9. And of course, we all know Ms. Jill Travis with Gactyl, who has spent hours and hours in here with us. So always good to see you.
Nice to be joining you.
We are in a point where Chairman Estration has talked about some concerns he has potentially and wants to offer some language. And so Chairman Estration, I appreciate you allowing me to interrupt you and you can proceed.
Well, thank you. I feel like I'm kind of jumping ahead of our witnesses, which isn't really fair. We haven't heard from you yet, but I might get called away. So I was just briefly trying to go over a few things that were on my mind. And I started what I said with, I think we're all together. I know I am together with the advocates on the need and importance of this legislation. It's all a mechanical issue of how does the language work and how is this going to be implemented is really what's on my mind. So just to be clear, because we were handed a substitute, it's everyone's understanding that this is going to allow for records restriction and sealing by the clerk of court after the passage of a certain amount of time for misdemeanor convictions. Is that right?
Yes, it would be petition based, so you would still have to go in front of a judge and it would ultimately be the judge's decision.
Understood. Okay, thank you. And the and this would be for up to a series of, well, it'd be 2 misdemeanor convictions, which could include accusations with multiple misdemeanors on each. Is that fair?
That's correct. Of
Okay.
course, that's where the judge's discretion could come in if the facts were particularly egregious in that situation.
Absolutely. But no felonies.
Felonies that have been pardoned would be eligible to go through the same petition-based process.
Thank you. I misspoke on that. That process, though, would result in the potential for, again, a records restriction and sealing of the clerk's record in a pardon.
Yes.
Sure.
And you would have to go through, I don't know if you're familiar with the pardon process, but it's very extensive. 11-page application. It takes 6 to 9 months to process the application. There's an investigation that's done. If there's a registered victim, the State Board of Pardons and Paroles reaches out to them. And since in the last 20 years, only about 10,000 pardons have been granted, about 400 last year. So we're not talking about a large number of people.
I understand that the list of offenses, misdemeanor offenses, which limit the availability of records restriction are very clearly spelled out here, and that might capture a lot of what I'm about to talk about. But as I think you all are aware, I just cited 246609A2. Evidence that a witness has been convicted of a crime shall be admissible regardless of the punishment, so misdemeanors, if it readily can be determined that establishing the elements of such crime required proof or admission of an act of dishonesty or making a false statement. So my question is, false report of a crime is a misdemeanor offense that's not included on your list of offenses. That would very clearly be, in my view, admissible for impeachment purposes under 24-609A1. I'm sorry, A2. And if I'm an attorney in a case and I know that a witness is coming in to testify, there's no means by which I can go to a clerk of court to check to see if there's been a previous conviction for that offense. Am I accurate in that hypothetical?
If it's been sealed, yes, but I mean, currently, of course, civil attorneys don't have access to an entire GCIC. They only have access to felony convictions. So, even under the current law, you would have to potentially go to every clerk of court in the state if you wanted to go looking for anything that might be out there.
Points well made. And just being a practitioner, I know many circuits have very easy to access websites. So you can check a website, see what's there, and then only go if you actually need to based upon what you find online. My proposal would be to address that on lines 425 and I've just done the sitting here, so let me know what you think, but it would be to strike except as otherwise provided by law and begin with in the course of a civil action and upon request, rather than an individual, replace that with the court shall strike reveal and replace it with order that any, and reading on from there, criminal history record information that has been restricted or sealed pursuant to this code section, and in place of the period, I'd replace it with for any witness in that civil action shall be provided to the parties in the proceeding, period. I want to thread the needle of just, yeah, sure. Yeah. So strike except as otherwise provided by law. On line 426, strike an individual and replace it with the court. Strike reveal and replace it with order that any. And on line 427, strike the period and replace it with for any witness in that civil action shall be provided to the parties in the proceeding. The final thing I'll mention is part 3, I believe is new. Is that a new addition that we didn't review in judiciary non-civil?
Which page?
I'm sorry, page 17.
That was in the final,
So-
at the end of our hearings, that was in there, because that's the language that was proposed by the chamber.
Okay. And so what we're talking about here is for, when I think of 24-4, I'm thinking of relevance and similar transactions or relevance in other acts which might be admissible in a proceeding. So what we're saying is that the criminal history information or a criminal conviction would be inadmissible as a matter of in the relevance code after it's been restricted in these circumstances.
That's correct.
Okay. All right. Do you see any conflict with 24-609?
I was looking at subsection C of 609, where it talks about that if someone's been pardoned, then you can't use it. And I know that there is a pardon piece in part 1. So
Of course, pardons are different. I guess I'm really getting at the conviction.
the unpardoned conviction that's been restricted pursuant to this new code section. I believe that that's threaded, and I want to just confirm that with my colleagues over here, but I think that works.
I'm not sure.
609C says that if you've been pardoned, then that can't be used.
Oh,
to
right.
impeach.
Yeah, I'm not talking
Yes.
about pardon. I'm only talking about restricted convictions.
Chairman Administration, so I'm just trying to make sure I understand the concern here. So we are, as the substitute is written without any changes, you're concerned that the admissibility of these fraudulent conviction of a fraudulent misdemeanor crime would not be admissible to impeach a witness.
I think that there appears to be, no, I think that there would be an issue with practitioners or parties having access to that prior conviction.
Well, there's two things. I'm seeing two things. And I want to make sure I clarify. One is the access, which I think you were trying to address previously. But this code section here, would that not restrict it from being admissible and used to impeach
I agree.
as well?
It appears to be in conflict.
Right.
To
Yeah.
chapter
I
6.
just want to make sure I understand it.
Yes,
So you've
that's
got two issues. One is you can't get access to it to even know if it's there to use it. And then secondarily, even if you were to get access to it, this section 3 might serve as a bar to it being admissible, even if you wanted to use it for impeachability purposes.
All right. Thank you.
Yeah, that's what, to make sure I understood that. So do we have witnesses want to comment on how the chairman's reading that so we can get some feedback?
I'm sure others may have something to say as well. I mean, it is a policy decision, like the chamber talked about, to limit the liability of employers, and it's something that other states have done. In many, in Georgia, this is called restriction and sealing because we just restrict access to the records. In many states, it's called expungement, and they actually destroy the records, and it's as if it never happened. So it is, a decision made in the drafting of this to protect employers in those, rare circumstances where this may come up.
Mr. Chairman, if I may, this is kind of a hybrid because this is actually language that the chamber was very much involved in wanting their protections. And so now you've got us in here with respect to kind of the access issue. And yet it's not something that of course we want employers to have protections, but it's not something that we came up with from the very beginning to ask for. I mean, I don't think that you could ever have a criminal trial or civil trial with putting Title 24 on the shelf and saying it doesn't apply. I think that whatever we do here, you still have all of the rules applicable for Title 24. One of the situations that I think that the employers were looking for purposes of protection is, for example, if somebody is charged with extortion and they have a battery conviction in their record and that's been restricted, the idea would be we don't necessarily, it doesn't bear a relationship. It's not directly relevant. I mean, if the battery was committed so that they could do the stealing, that might be far-fetched. You'd have to go down a long line to get there, but that's my understanding of sort of why the chamber was looking for employers to have some protections to hire folks.
So if you're an employee of ADP and you've had a prior conviction for some fraudulent transactions, then and ADP goes out and says, I want to hire this individual because I'm in good faith going to participate in trying to put people back to work, and this employee steals money. And the company for which ADP was working for, perhaps my law firm, and my law firm wants to sue to recover, then this previous information regarding this particular employee would not be admissible in those proceedings against ADP to recover. Am I getting this right?
Well, the financial institutions are different. And I don't have the new substitute other than sort of on my phone that I'm trying to follow. But somewhere, if you're looking at subsection U, which is right above part 2, there are specific requirements for financial institutions that are carved out. And financial institutions is defined very broadly. So you're never going to have that worry, Mr. Chairman, with regard to financial institutions.
And also, if I might add, I don't believe that I think that the only crime that's touched by this is the misdemeanor theft by shoplifting. All the other thefts are not included in
Okay.
this.
But, yeah, but misdemeanor forgery, right? It's not on the list.
Not when you say not on the list, I need to know what that means.
Page 8, the list of offenses for which restriction will not apply.
Oh,
So beginning at
so it would,
253.
so then it means it could be restricted then?
Yes,
Yes.
That's what I want.
restricted and sealed.
Yeah, if we can talk about it using restricted versus sealed or restricted and sealed, that helps me understand. So that would be restricted then.
It would be restricted and sealed. And if I have a civil case pending against, if I have a civil case pending and a witness is called, there's no way that I know of that an attorney can get access to that conviction if it has been restricted and sealed for use at trial. I think so. Yeah, I think the amendment addresses it. I would then petition the court. I'd have to request it, but then the court could issue an order or shall issue an order providing that information to the parties.
But I wouldn't be able to use that information then if it's not a financial institution. So if I have an employee that fraudulently executes documents and it affects the outcome of a case or the formation of a trust, then and the beneficiaries of that trust wanted to sue in malpractice, and they would not have access to that information in order to use that to impeach the employee's testimony with the section 3 that we have here. Is that so? Taking out of a financial institution situation and putting it into a different one.
Yeah, I think that's accurate. The access, as you correctly identified earlier, the access issue and the admissibility issue are important to separate here. And the language that I was using earlier was to address the access issue.
Yeah. But then the second section 3, the section 3 that you were pointing to would then prevent that evidence from being, even if I could get access to it, I couldn't present it.
Unless it's relevant to the facts.
Okay. All right. And in that context, it would be relevant. Yeah. Okay.
Well, okay. But if we're talking about impeachment, that's not necessarily relevant to the facts of the proceeding. It's only being admitted to go to the truthfulness, propensity for truthfulness of the witness. So. Can you add that?
Yeah. Can we add that if it's relevant, if it's not relevant to the facts of the inline proceeding or goes to the truthfulness of the witness, the veracity of the witness? So you can put at the end of that after proceeding or the veracity of the witness.
Yes, I think that addresses the issue.
we'll hold these, obviously, these are, while Chairman Administration's here, I certainly want him to have his, get the say in it and get the language. We'll be at Chairman Clinton.
My question is simple. Are the proponents of the bill going to oppose Chairman Administration's two amendments?
I think they're more concerned with the record restrictions, but the business community may oppose that.
This. Yeah. it's true.
I'll just say I can only speak for myself, and just to say the amendment that Chairman Welch just made, very good with me.
What about the one
Totally.
administration made?
Now, the one that Chairman Administration made, I just didn't hear it. I was like, because I'm on my phone and I'm trying to figure out, and now I have it down in paper. So I just didn't quite follow it. It sounded pretty good, but I just don't want to say, yes, that's perfectly fine without following
Of course,
it.
yeah.
It sounded like it made sense, but just
Would
being
you like me
honest.
just to read the language as it would read in the?
Yeah, that would be great. And can you direct me to the line number
So,
again?
yeah, so line 425.
We're gonna give you a copy.
I have it now, yeah. Um,
Thanks, Evan.
Mr. Chairman, I'm not proposing that as an amendment. I just wanted to understand.
I'm happy to propose it. Yeah,
I just wanted to make sure I understood the issues that the chairman was making, and then work towards at least solutions that address that, whether I'll render my decision later.
my issue is addressed with in lines 425 to 427 at reading. In the course of a civil action and upon request, the court shall order that any criminal history record information that has been restricted or sealed pursuant to this code section for any witness in that civil action shall be provided to the parties in the proceeding period. Okay, that's it. And then it was what Chairman Welch said earlier, which I guess you said you had no issue with. It be on line 581, ending with or the veracity of the witness. Those would be my proposed amendments if I'm out. Thank you.
Mr. Chairman, since the chamber doesn't have their lawyer here, will you explain to me why you think they may not like that?
I said they may. I can't speak for them either way.
I know that, but I mean, I don't understand why they may not like it.
I don't know if I do either.
It works. It seems to work to me that that the way this is written would provide a pretty broad exclusion to the admissibility of evidence to be used against the employee or employer. So it is narrowing the scope of evidence that could be used to harm it and to harm the employer. If it's not relevant to the facts of the underlying proceeding or the veracity of the witness, now that opens it up a bit to allow it to be used when the information is, we have double negatives in this work here, when it is relevant to the veracity of the witness. So by adding that, we are opening it up a little bit to the exposure that the employer may have, because now this evidence does get in.
And of course, my objective here is to provide consistency in the evidence code. I think that this amendment, I would propose this amendment because I believe it does.
Both amendments.
Both amendments.
Jill, did I say that correctly? Robert, did I? Just from a legal perspective, not from I'm not asking you about the chamber's opinion on it or their lawyer's opinion on it, but that's the way I read this change, is that would be the effect.
So Chairman Welch, if I may, Mr. Chairman, the employer is being sued. That's our scenario.
Yes.
We've just done something that opens up more liability for them by being able to bring out what their employee did in the past. Is that correct?
That's correct.
Now, they did not know that because the record was sealed to them, correct?
Unless the employee told them in the course of the interview, yes.
And so I'm trying, so the witness is on the stand, the company's being sued, and it comes out through opposing counsel that they had prior arrests and prior convictions, misdemeanors, I would assume. And the concern would be that that would prejudice the jury against the company because they now have hired someone with prior bad acts.
Could.
And without these two changes that Chairman Administration has proposed, that is lessened.
Not the first change, the second change, because having the ability to know it may not render it admissible with this section 3. So even the removing the restriction, or at least having access to the records to learn about it, is what is in the first part, is what Chairman Administration's language is before. The section 3 language deals whether or not it gets into court before a jury. So it's 2 steps. You got to be able to find it, and then you got to be able to use it in court. And step 1 is his first changes to page 8 and 9, and then this other one deals with admissibility to the court, so the jury could hear it. But you're right. I mean, that's what it does. Is it now makes it it now allows it to be put before the jury. Even if it's just going to the veracity of the witness, we know that juries are going to hear that, and that may have an effect on
So
their
you
opinion.
put the company's counsel in the position of arguing, yes, this person that works for us did have prior arrests, but we didn't know that when we hired him or her because of the fact that Georgia law sealed those records. And the only reason the other counsel was able to get to it is because there is an exception or an unsealing of those records when you're trying to prove the veracity of a witness.
Yeah, a little bit, but that raises a question, Chairman Administration, is with the language you have in the previous section that opens up that, would I be as an employer expected then to go and check those myself as well? Can I, and would I be expected to, and would that create a duty on me to do so because of section 3? If we open section 3 up a little bit, I don't know the answer to that.
So if I understand your question, it's the accessibility to those otherwise sealed and restricted records. Would that then put some responsibility on another party? I don't view it that way, because there would have to be pending litigation, and maybe in addition to that First Amendment that I outlined would be for use only in that proceeding, so that it's not more expansive in the use. I'd be fine with that.
Yeah, but that's I think that's where Chairman Fleming is leading me down to. I don't know if that's where you're going, but I don't want to create, if we open this up, because it may be prudent to do so for consistency in the evidence code. I don't want to inadvertently create a duty that a plaintiff's lawyer might use to hold the employer liable for the actions of the employee, if there was a way in which the employer could have found out. You could have known, and you should have known, and therefore you're liable.
So that would require that there had been a previous civil case where the employer and the employee were parties to the same case. I can't think of a circumstance where that would arise. So I don't believe that there's a risk of that. But we've discussed throughout potential abuses when records do become known. And if there's any concern that the records might be records provided to parties. You know, by the way, we also have on the next page, 437 to 446. Well, maybe that will apply, because 445 is the confidentiality shall be maintained of the record. So we could just cite to that, but
would you could you write out the the change to your language that would then remove that possible duty for the, or that possible ability to know for a lawyer, for the employer?
Yeah, so I would just add on to my First Amendment at the end for use in that proceeding.
Okay. Looked like Robert had a,
May I interject one small request? Since we're talking about making someone disclose or reveal criminal history record information, the definition in 35-330 of criminal history record information includes such things as the age and sex of each victim as provided. Is there a way we could, would the committee consider putting a modifier into that definition to reveal relevant, reveal pertinent, reveal, just kind of modify or narrow that rather than putting a duty on the former defendant to have to go and disclose information about their victim or something like that? I was going to say either relevant or,
where are you exactly, Robert?
on line 426 after Chairman Abstrations.
Oh, yeah.
The court shall reveal criminal history record information. Just the court shall reveal relevant, pertinent, appropriate, since it's a judge making that decision.
He said court order that any criminal history record. Do you want to say order that any relevant?
Yes, sir. Just because of that, because just trying to, you can reveal the disposition of a case, and that's really all that they're looking for in this instance. Not wanting to get too much into the weeds of the actual events.
Yes.
Yeah. Chairman Shirley Ridge, been waiting patiently.
Sorry.
I'm sorry.
Thank you. And actually, much of what I wanted to comment on has actually been discussed with limiting the information that's revealed to that proceeding in which it's revealed. I just wanted to note that if it's not required to continue to be subject to maybe a sealing order in that particular case, then it has the potential to get out and defeat the purpose behind this whole bill. So I just wanted to, I think that it's been helped a lot by adding the language for use in that proceeding. We should probably say only that proceeding, and then consider, yes. And then consider maybe some further language that requires that that there be a sealing order or something to that effect.
Such order shall remain sealed. Is that if you're talking about the order that the court in terms of
Any information disclosed in such order shall remain sealed.
Yeah, because the suggested amendment is requiring the court who's considering the matter to order that any of the restricted information be provided. So I think we should probably do something to require that court enter or order it subject to a sealing order for use only by the parties in that proceeding and then be destroyed. That's the way that sensitive documents are typically handled when they're revealed only for use in a proceeding.
Is that the language? I want to make sure we're focusing on the proper language as to what that would sound like there. So you're saying for use only in that proceeding and that upon the shall be destroyed. Ms. Travis?
I was just going to say, what I think we're doing is you're saying we're going to open the door to the litigants, right? The litigants have a right to have this information. Once those litigants have the information, first of all, we want them to preserve confidentiality. And once we're done with that civil action, we want to close the door again. We don't want it to go out any further.
The door's going to be closed because nobody else can get to that information. And once it's said publicly in court, it's a matter of record. So I'm trying to figure out how you're going to unring that bell.
Yeah.
But the bell is not going to be heard that far. It's going to be in that court. Now, anybody gets a court proceeding can certainly order the transcript and read the records. But I'm trying to figure out how you're going to unring that bell. And I think the bell sound is not going to go that far. That's why I'm trying to figure out what are we trying to do.
Unless the the litigants are allowed to copy and distribute the information posted on the internet.
Well, the court record is going to contain that
That's right. The
information.
court record
And
would.
the court record is not going to be sealed.
Right, right. But I'm just saying that to further the policy purpose behind this legislation, it would be helpful if the litigants were not allowed to post it on the internet. Someone would have to go to the trouble of getting to the court record.
Well, what you're saying now is that a litigant would not be allowed to report what publicly happened in court.
Well, they wouldn't be, I'm proposing that they not be allowed to make public the documents. I mean, there's a possibility too that these documents are not ever going to be used in court. So you're assuming that the judge is going to allow it in. They may not. Because what Chairman Efstration wants is to have access to these records, to see them. He may not ever use them. They may not ever come in and become part of a public record.
So the two parties in court, as I understand it, is someone suing the employer and someone being sued, the employer, and the employee in question with a past criminal record that has now been sealed, basically, is on the stand, and this information comes out because of that person's veracity. So who in those parties is going to want to publish this information?
I really don't know. I mean, there could be parties who would want to for various reasons. And again, it's still the information may not ever become part of the court record. Just because the attorney has access to them doesn't mean that they become part of it. And I mean, I think if you're going to have this, you should.
There may be a way to very reasonably write that into here. I just, I'm thinking that we're writing a paragraph now, and we're going to try to figure out how to do that tonight. And that may be much easier said than, that may be very easy to do. I'm wondering, because nobody's proposing any language, how we're going to do that.
Right.
With law
And
enforcement.
also I'm judging that against the size of the problem that we're creating. My instincts are that it's a fairly small problem that we're creating, and the underlying bill is good enough to take the chance on that small problem. I could be wrong.
That's what I said.
What about, what if we added, any information disclosed in such order shall not be published outside the proceedings, including appeal?
Shall not be used in an appeal?
No, shall not be published outside the proceedings, including an appeal.
Meaning it could be allowed in the appeal.
Mhm.
It's fine with me.
Repeat that language.
Yes.
We need to start with a new sentence.
So it would be after the changes that the Chairman Administration had given to us before, it would just say any information disclosed in such order shall not be published outside the proceedings, including an appeal.
Excluding an appeal. Because you want that information to be used in an appeal, potentially. You want the court record to be used in an appeal.
Yes, I do.
Repeat it one more time.
Any information disclosed in such order shall not be published outside the proceedings, and I had including an appeal, and Chairman Fleming says it should be excluding an appeal.
What if we just said such proceedings and any subsequent appeal?
That's fine.
Mhm.
Because I'm honestly not sure which one of y'all is right.
Right.
I'm not even.
This chairman's about as good as the judiciary chairman.
That's good. I'm comfortable with that language.
Okay. Well, we've kind of got off into some language discussions there, and we looped in our witnesses to help with that. And I did not, because of the pressing time with Chairman Efstration, give you what I would consider is the proper way to introduce yourself, and any policy comments, any comments you want to make relevant to the policy we're putting forward today. And Brenda, I'll start with you.
Thank you. As I said before, I am here on behalf of the Georgia Justice Project. And if you're not familiar with us, over the last 15 years, we've represented thousands of people around the state in helping them to clean up their criminal record to the extent that it's possible under the current law. And then we've also partnered with prosecutors and community members all around the state to hold over 40 record restriction summits. And we're working on figuring out how to take those events virtual with some jurisdictions. And I'm also here on behalf of the Second Chance for Georgia campaign. And I believe some of the Senator Anderson and others have mentioned that there is a wide array of organizations that have endorsed this campaign. So far, we have 74 organizations that have stepped up and said they care deeply about this issue and want to see Georgia improve our law, representing really diverse perspectives from religious organizations to conservative organizations and organizations like the Southern Center for Human Rights and the Urban League of Greater Atlanta, as well as thousands of individuals who have signed up to be a part of that campaign. And these organizations care so much about this issue because, if others have mentioned, having a criminal conviction can be a life sentence to poverty, no matter how long the actual sentence was. And others have mentioned that Georgia is very far behind in this. Over 40 states, there are additional mechanisms to be able to remove convictions from your record. The only convictions that we can remove right now under the restriction law are certain misdemeanors that an individual was convicted of before they turned 21. And every record remedy that we have is backward looking. It's about what was going on then, how old the person was, whether or not they were eligible for first offender. We don't have anything that's looking at who the individual is today. So we're not recognizing redemption and rehabilitation in our law. And people who are years from their past still suffer the stigma of having a criminal record. So SB 288 is a modest step compared to what other states have done. Just to summarize, as others have stated, up to 2 misdemeanors or incidents, the individual would have to wait until 4 years after they've completed their sentence. So since most misdemeanor sentences are 6 to 12 months, we're talking about 5 years after the conduct or the conviction. And then pardoned felonies, as I mentioned, that's a very strenuous process. Not a lot of folks are granted a pardon. So we're talking about a small number of folks there that have had their rehabilitation recognized by the state. And they can't apply for that remedy until 5 years after they complete their sentence. One thing to note is that law enforcement always maintains access to records in Georgia, including prosecutors. And we've already talked quite a bit about the liability protections, so I certainly won't go into that. Also, we are utilizing a petition-based process that's been in effect since 2013 for youthful offenders, and it's working well, where the judge has to decide and the prosecutor has an opportunity to object. So the bill you have in front of you doesn't necessarily go as far as, thank you so much, as what we as advocates would like to see in some of our partners. It's been refined and amended more times than I can count, but we've been soliciting the feedback and incorporating the feedback of numerous stakeholders, businesses, prosecutors, community groups, legislators, and judges over these recent years. So we feel like it is a very moderate proposal that many folks can agree on. Also, the last rewrite of the expungement law happened in 2012 at the beginning of the Council on Criminal Justice Reform, but that was never intended to be the end. In 2013, the Senate, a Senate study committee actually recommended expanding expungement to include felonies. And then in 2018, the Council recommended expanding it. We just haven't been able to agree on these details. But Georgia does continue to lag. Even of those 9 states that don't have a way to expunge convictions, 3 of them have other remedies such as set-asides that allow people to move on from their record. So we are really behind the curve there. It is, SB 288 is more important now than ever. It will help, as Senator Anderson said, create a more inclusive and equitable economy. And we can't afford to leave behind those 4.3 million Georgians that do have a criminal record. And it is about putting people back to work. So there are some good studies and some good research. And one of the handouts that hopefully you received in your packet references some of those studies. If you didn't, I'm happy to leave a copy of that. But one study by the University of Michigan found that getting an expungement increases the likelihood of employment by 11% in the first year and wages by about 22% within the first year. Another study that's a number of years old, so the number's probably a little higher now, out of Stanford found that expungement leads to an average increase of about $6,200 in the first year after the expungement. There's a new study that just came out of Pennsylvania that showed for 819 individuals that had their record pardoned and sealed there, in the first year, they had 16.5 million additional earnings than what they would have had without that remedy. And one additional, to come back to something that Chairman Welch mentioned earlier about, there are numerous studies about recidivism and the importance of employment in reducing recidivism. One study showed that employment opportunities, work opportunities can reduce recidivism by up to 43%. Also, most people that are getting, by and large, most people that get in trouble are going to get in trouble within the first 3 years after their conviction. Also, based on other states that have expanded their law, there's a study out of the University of Michigan where they found that people who had received an expungement had less than a 2% rate of recidivism after 5 years. Last thing I want to mention is that many people, now more than ever, people are engaging in conversations about and highlighting racial disparities at every level of the criminal legal system. For example, you might be familiar with the research around marijuana arrest. Black people and white people use marijuana at roughly the same rate, but nationwide, you're about 3.5 times more likely to get arrested if you're Black. In Georgia, in some counties, in Fulton County, it was about over 7% or 700 times more likely to, 7 times more likely to get arrested, and in some counties up to 14 times more likely to get arrested if you are Black. What some people might not realize is that there are also racial disparities once you have a record. The most prominent study that has come out about this is a researcher named Diva Pager, and I can provide the citation for that study if you like, but she sent test subjects out to apply for jobs. Some were Black and some were white, some were Latino, some had a record and some did not. And what she found is that if you had a record and you were white, there was a 50% lower likelihood, you were 50% less likely to get a call back for an interview. But if you were Black, you were 64% less likely to get a call back for an interview. And shockingly, what she found is that a white man with a felony conviction was still more likely to get a call back than a Black man that had no record whatsoever. So we always want to be mindful of the fact that when we're talking about criminal records issues, we're talking about the intersection with employment discrimination. So people who have had a record, as Senator Anders said, are looking for hope and an opportunity to compete, particularly in this economy right now. and to have a chance to take care of their families. So we are hopeful that this committee will pass out this law as amended.
Thank you, Ms. Smeaton. Questions for Ms. Smeaton? Chairman Welch?
Chairman, Ms. Beaton, could you speak to me and help me understand lines 283 through 291? This deals with the series of I guess it's one conviction, but it's a series of accusations. And I did not get a chance to ask Chairman Efstration his concern that you noticed he raised a lot of questions, and then I was trying to make sure I understood what was the underlying issue that he had with the question. So, and he has left us. So I wanted to understand what this is doing, and then I'm going to try to divine what he was thinking when he pointed that out to the committee. Could you just explain those lines to us?
Sure. So what it's saying is that you can apply for one misdemeanor or a series of misdemeanors. So misdemeanors that may have happened in the same incident. So say you were arrested for a fray and misdemeanor marijuana possession at the same time. You would be able to restrict and seal that as an incident, that wouldn't count as, two separate restrictions for two separate charges. That if it's charged in the same accusation or indictment, we are talking about, one incident that could potentially be restricted and sealed. And that is, of course, as I mentioned to Chairman Efstration, where the judge's discretion comes in. If this was the rare incident where somebody had been charged with 10 misdemeanors, which the data from GCIC says that's extremely rare. I do have the data somewhere here, but I believe 96% of individuals who have misdemeanor convictions, they have less than 5 convictions on their record, and over 60% of them have only 1 conviction on their record. And it also says that if you're denied, you have to wait for 2 years after the denial before you can reapply. Did I answer your question?
No, you did. Yes, that helps. I think it sounds like the chairman was just concerned about there being situations where there's multiple misdemeanors, and this is a sort of a, for lack of a better word, a kind of an aggravated case where you had many misdemeanors piling up, and then you get to wipe all of them clean. Or have them restricted, I should say, then there seemed to be some concern about those situations. But you've said that you very rarely have a piling on of misdemeanors, so it's not the likelihood is low, and then you have the judge reviewing it anyway. So there's some oversight in how that's administered. So I feel comfortable with that. That was what I was concerned about. I wasn't sure.
Thank you, Chairman
Thank you.
Welch. And Ms. Smeaton, thank you for your work on this issue. I'm going to go over to Mr. Smith, and you asked and for a couple changes in the bill, and I know we've incorporated some of those into the sub. I know Ms. Travis had some concerns, and then y'all are working together, but y'all think y'all are okay now seeing the language. Why don't y'all, do you want to briefly tell us about PAC or your position on the bill?
Since the criminal justice reform initiatives of the previous administration, the prosecutors have been partners, and we continue to be a partner in this instance. This is we've been working with Georgia Justice Project to provide people that are deserving and needing a second chance to get that second chance, especially when it comes to employment and housing issues. We support this bill, especially the concepts, and I want to echo Chairman Efstration's comments about that the concerns are not about the policy, it's more about the mechanisms that are involved here. And that's one of the issues and one of the concerns I had was making sure that when a prosecutor's file is still allowed to be maintained and used in such fashion that we're not restricting it and getting access to the work product and preventing that from being able to be used in an appropriate manner. And that's part of the conversation that Ms. Travis and I have had. And I think that we have reached an accord with some of the language. But as to section 1, I think that's I think I could say that our membership has been involved in the drafting of this, and we are solely behind. We are completely behind it. Section 2 is where we've just had some quibbles with some of the wording.
Are those quibbles resolved?
I believe that they are. I'm going to turn over and look at Ms. Travis. One of the big ones is that when you reference the word restrict or restriction, and then also say disseminate, it shall not be disseminated. So once you've restricted something, then say it shall not be disseminated. What exactly does that mean? And that was kind of what Ms. Travis and I were having a conversation out in the hallway about what, to make sure that, because our appellate courts, are always talking about making sure that words have meaning and that each word that this deliberative body puts into the laws is a word that has a meaning and must be given a meaning. So when you say to restrict something and then also not to disseminate it, let's make sure we understand exactly what we mean by that.
Mr. Chairman, may I ask about the line? Is that line 510? Or?
Yes, sir. Line 510. It also appeared earlier in 477.
And so it says there at line 10, the defendant's records restricted from dissemination, not restricted and barred from dissemination. So it's different than what you just said. So I want to make sure I'm understanding the concern. It says restricted from dissemination.
And that's why and I would, if we're going to talk about things, I would like if the words from dissemination were removed, the defendant's record shall be restricted. And then you go back and look and see what it means to be restricted. It reaches the same goal. The from dissemination is excess wording.
What was the other line that you were referring to for?
The other line was removed already.
If you take line 510 and replace it with the language that's on lines 477, 478.
Which says the defendant's record shall be restricted in accordance with code section 35-3-37. Is that correct?
Yes.
To give it a background of it, may I?
Oh, absolutely.
The issue is once a record is restricted, whether or not, that's the end of the story. And when does that happen? And under the language that you see on lines 510 and then section 2-3 are lifted almost exclusively from the first offender law. And the prosecuting attorney's counsel is asking for some revisions. And I understand the revision requested. The idea has never been ever to restrict information to go to law enforcement or prosecuting attorney's counsel. They should always have access to this information. We 100% agree with that. We do, however, think that when a record is restricted by a court of law, that should have meaning from the time that that is imparted, and that the end around to go to a prosecuting attorney's office and do an open records request and ask for it should not be another way for access. Of course, probably to Chairman Fleming's knowledge, he would say, well, if somebody was in court, they would know about it. And that's true. We can't stop what happens in court. We can't stop somebody from telling a neighbor, but we do want to stop proliferation of records to the extent possible. We're in agreement with the prosecuting attorney's counsel on the changes.
So GACTO is supportive of changing line 510 to read, striking that line and inserting the language that's found at lines 477 and 478. Is that correct?
Yes, sir.
All right. If y'all will, I'm going to bring in some other witnesses. But if y'all would just move to the back of the room, because I'm sure your expertise could be needed by us by the time we get there. Ryan, will you get Mr. Thomas Weaver for us?
I hope so. really disappointed to see him move on, but hopefully gave you guys a good one. Question is, do you have procedures to vote for? We do. I know you got rain bats.
Mr. Weaver, just sit at any of the, well, sit at mic 5 over there for us. We've got a little different setup here during the COVID crisis. And we appreciate you being here. Know you're no stranger to this committee, and always enjoy getting to hear what you have to say. And we're taking up Senate Bill 288. And if you'll just state your name for us and then share your thoughts.
Thank you, Chairman Kelly, members of the committee. My name is Thomas Weaver, and I'm a private citizen here in the state of Georgia, and I have gone through great strides to participate in the legislative process both this year and in many years gone by, and I rise today in support and approbation of the legislative efforts that have been presented to you by Senator Anderson under Senate Bill 288 in its most current rendition that this committee is working off today. However, having not had a chance to see the substantive changes that are included in the LC number that the committee is working on, I can only glean the exact language based on what I had learned from listening into the Zoom out in the hallway. I don't want to go into any specifics. It's not about me. It's about what's best for public policy that you're trying to draft for the people of the state of Georgia by and through this measure. However, I do have a large ask, and perhaps maybe this boulder's too big to lift, but it is something that's weighed heavy on my heart, and I have asked this in many sessions gone by as this bill has worked its way through the years since its inception back in 2012, and each rendition thereafter, as is codified in the official code of Georgia, annotated on file with the records of the Secretary of the State, and all of the different Senate bills and even the initial House bills that that breathed life into this statute since the code was, I guess you could say, overall amended back in 1981. Today I present my testimony to you as a convicted criminal in the state of Georgia for a crime that no longer exists. The Georgia General Assembly a few sessions back made a public policy decision to repeal an underlining statute that I was convicted of and other elements of another statute upon which was the foundation for my initial arrest. So, interestingly, records on file with the center demonstrate that I'm a convicted misdemeanor for a misdemeanor crime that for something that today isn't a crime at all. And unfortunately, due to the current rendition of the records restriction statute under Georgia Code Section 35-3-37, I am statutorily precluded from being eligible for records restriction because I was convicted of an underlining lesser included misdemeanor of the offense charged. And because of the lesser included language, that is definitely part of the statute under subsection H of the code today. And I went through and petitioned the Superior Court and hired an attorney to do all this. And indeed, the court ruled that categorically I'm ineligible. I'm grateful to hear that the legislature is considering allowing for a records restriction process for misdemeanors. However, I was desirous to ask if it should meet with this committee's approval, if the chair should choose to allow it, and if it would be okay with all of the many stakeholders who have spent countless hours working on this bill, if there would be any oxygen in the room to allow for language to be included as a rider to this measure that would provide that the criminal history of a person shall be, I guess you could say, restricted by the center or ordered to be restricted by the court if that individual has been convicted of an offense that no longer exists that the legislature has since repealed. I don't know if that would fly in the face of public policy when you consider crafting your public policy decisions, because ostensibly there may be some who take the hardline view that no, the crime was on the books when the incident occurred and you were adjudicated by a court of having broken that law. So we're not going to go through any new policy here and go back in time and allow you to escape the collateral consequences associated with that criminal offense that used to exist but no longer does. But I'm asking you if you would be willing to consider adding a new subsection to this code section that would specifically authorize a criminal defendant to petition the court for a records restriction if the elements of the offense or the underlining offense itself is an offense that the legislature has since repealed. I know that that might not be something that this committee would be receptive to or not. I can't say, but it's an ask. I'm asking this committee to consider it.
And I'm trying to think through here, Mr. Weaver, whether in your situation under the proposed law, if you would be able to now more successfully petition. And I would maybe lean on Ms. Smeaton, if you could maybe give some clarification on that. My understanding of the legislation would be unless you're one of the restricted offenses, that any prior that meets with any previous offender that meets, the measures here would be eligible. So it would sound like, in my opinion, Mr. Weaver, that under the proposed legislation, that you may be eligible. I would ask Ms. being the maybe just, am I understanding everything correctly here?
Yes, you are, Chairman. And that would be my hope. However, without having an opportunity to lay eyes and actually read the substantive changes of the bill based on the most current LC printer rendition numbers presented to you by the Office of Legislative Counsel, I don't know. And
the most recent substitute,
thank you.
it won't have any of the suggested language that we've been.
I would just say that none of the exceptions, I don't know what your particular situation is. I'm happy to talk to you outside of this room, but none of the exceptions have changed in the discussions that we've had today. So if it didn't fall under one of the exceptions, then you should be eligible through the process.
And I'm grateful to hear that. And I indeed will accept her offer, and I will speak to her about that. But again, notwithstanding what this and having an opportunity to fully read it, I thank you, Chairman, for gifting me this. But it was just an ask of the committee if this committee would be receptive to just briefly creating the amendment, if the chair and the committee should choose to allow it, creating a new subsection that would specifically direct the courts and the center to restrict access to record histories for previously existing crimes that the legislature has since repealed.
All right, we're Chairman Welch.
Yeah, I understand the earnestness of the request, and that I think the issue would be something that we want to discuss in private to make sure you understand whether that applies in this case and whether or not that could be restricted if this bill becomes law. The reason why I'm hesitating on a language that you're suggesting, which would be a broad policy statement that misdemeanors that have been repealed is too broad. And the only reason why it's too broad and trying to craft that here is because we may pass laws to repeal something where we actually have put it back into code somewhere else. And so that you may inadvertently have captured so many things that could arguably by a skillful lawyer argued that, oh, well, this was in fact repealed. Well, it was repealed, but it was actually put back in code somewhere else. And we do that sometimes. So I think we would need to get real specific. And so the first thing to do is to do exactly what Chairman Kelly is saying. Let's find out if this isn't covered already, and then we don't need to touch the language. If it is not covered, then maybe that is something we want to look at, because we did pass a repealer bill that went back and repealed several conviction or laws that were violative of the federal Constitution. It was a cleanup bill, but we have done that in the past, and perhaps that falls into that category, which would make sense that it isn't even constitutional to prosecute for those cases, those particular alleged crimes at the time. And so that would make sense in a way. So if I've understood you correctly, then those would be the two steps that I would think that would be appropriate at this point.
I absolutely agree. And I look forward to being able to read this measure in its most current rendition to see if my request was superfluous. However, I didn't want to let the opportunity slip through my fingers to at least ask.
Appreciate it. I see you in the hallways. I smile. I just enjoy hearing your presentations, and the depth of your knowledge is impressive for a constituent that comes here periodically. You don't even come here every single committee session, and oftentimes you're more eloquent than some of my colleagues in my law practice.
Well, Darren, I thank you, but again, I look forward to being able to read this based on the generosity of the chair and also speaking with her out in the hallway, and perhaps I can learn more myself. We all learn here.
Thank you, Mr. Roy. We appreciate you being here with us.
Thank you.
Thank you. All right, we have one more witness, Tim Head with Faith and Freedom Coalition. Number 5 will be well.
Thank you very much. My name is Timothy Head with the Faith and Freedom Coalition, and pleased to be with you today. Y'all have been very thorough, I think, in the treatment of this, and so I won't belabor any of it, but did want to just add our support for not only the policy, but the what looks like maybe the final version of this bill. We appreciate your willingness to take this up. We know that time is precious in these in this 2 weeks that we're looking at here in the legislative session, and so we really believe that this has always been an important issue, but in the throes of kind of the outcome of COVID and the impact on our economy here in Georgia, we actually think that this can actually be a really meaningful employment situation for literally probably close to 1 million Georgians. And so we thank you for the timing for a lot of folks that really need it very desperately. So I think that this is a critical measure and a critical moment, and so we're pleased to be able to support a bill like this that we know that it's taken a number of years in the making, but I think we're approaching the home stretch here, and I think that this is very precise, and I think that these kind of measured approaches is exactly what we need right now in our justice system. So thank you.
Any questions for Mr. Head? Cindy, thank you for being here with us. All right, that's all the witnesses that are signed up to speak. The bill will now go before the committee. What's the committee's pleasure? We got a motion from Chairman Fleming, a second from Chairman Green. Now would be the proper time, Mr. Chairman.
I'd like to move, Mr. Chairman, the 2 illustration amendments that we worked out earlier.
And we'll let Evan read those.
Does Mr. Huh?
You got them? All right. Well, then we'll let Chairman Welch read them.
Evan will double check me if I've got it right. I think the first one is at line 425. Strike the language except as otherwise provided by law, comma, capitalize the I and N. At line 426, strike the language "an individual" and replace with "the court." Strike the word "reveal" and insert the language "order that any relevant." At line 427, after the word "section" and before the period, insert the language "for any witness in that civil action shall be provided to the parties in that proceeding for use only in that proceeding." And then insert after the period in line 427, "any information disclosed in such order shall not be published outside the proceedings and any subsequent appeal period."
We'll take that as the first amendment. Do we have any objection to that amendment? All right, not hearing any, not seeing any, that amendment is in. The second one?
Evan, I got it right. Second amendment, this will be the second abstration amendment, is at line 581. After the word "proceeding" and before the semicolon, insert "or the veracity of the witness."
Any objection to that amendment? Hearing none, seeing none, that is in.
One more amendment.
One more amendment.
At line 510, striking the language of line 510 and inserting in lieu thereof the following parentheses lowercase I in parentheses the defendant's apostrophe S record shall be restricted in accordance with the code section 35-3-37 semicolon.
Any objections to that amendment? Hearing none, seeing none, that is in. Any further amendments? All right, hearing none, seeing none, we'll now call the question on LC 28. Will be the it'll be the committee substitute to LC 289817S, the committee substitute to Senate Bill 288. All those in favor, make it known by saying aye. All
Aye.
those in the room.
Aye.
All right, any and everyone, we will mute the mics and we will go to the computers. All those watching from home.
Aye.
All right, and now for the room. Do we have anyone who will vote no? Make it be known by saying no. The bill passes unanimously. Thank you for everyone's hard work today. Representative Gaines, Representative Senator Anderson, the bill will now go to rules. Senator Chairman Smith has a form that he would like you to fill out, and I believe I have to sign it. Is that correct, Evan?
Yes, you have to sign that.
Okay, you can get with me and my office about signing that as well. Thank y'all. There's no other business come before the committee. We stand adjourned.